Welcome back, everyone. Today's courtroom hearing starts as a relatively straightforward misdemeanor case, but the deeper the judge digs, the more complicated this situation becomes. A Michigan defendant is facing allegations of property destruction and domestic violence, but that's only part of the story. As the hearing unfolds, questions emerge about prior criminal history, parole status, alleged attempts to avoid detection, and whether this defendant can be trusted to follow court orders if released. The defense argues he has strong community ties, steady work, and family support. The prosecution paints a very different picture. Stay tuned, because a seemingly routine bond hearing quickly turns into a detailed examination of risk, credibility, and public safety. And pay close attention. The judge's final decision may not be what everyone in the courtroom was hoping for.
All right, this is the people of the state of Michigan versus John Henry Stats, case number 261736 SM. Mr. Stats, you met with somebody from Community Corrections Day and gave them some contact information. Was that information accurate?
Yes.
I think there's a spelling mistake in your street name, but I just want to confirm that. It should end in CE, correct? Not SE?
Yes.
LaChance?
Yes, it should be CE.
All right. And is that Lake City then?
Yes, it is.
Did you have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, I did.
I have a complaint that alleges that on or about May 10th, 2026 in Liberty Township of Wexford County, it is alleged in count number 1 that you committed the offense of malicious destruction of personal property, $200 or more, but less than $1,000 in a domestic relationship. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the value of the property damaged, whichever is greater. And it looks like that's in regards to a truck windshield. In count number 2,
domestic violence.
Well, so that's what I'm getting to next.
Okay.
So they've also charged you with domestic violence in count number 2. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. If the assault happened in a place of confinement, consecutive sentence may be imposed. So whatever information was presented to the prosecutor today, they've charged you both with MDOP, 200 to 1,000, and domestic violence. Do you understand that?
Yeah.
You also understand the potential penalties arising out of that?
Yep.
Did you receive, did you read and sign an advice of rights form at the jail talking about your rights to an attorney and your rights to a trial? Did you understand those rights?
Yes, I do, Your Honor.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of an attorney.
All right, court will make a referral to the public defender's office while entering not guilty plea and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the public. Counsel, the praxis scores him at a risk level 3. And historically, I show in 16 a driving license suspended, in 20 possession of narcotic less than 25 grams, 21 false report of a misdemeanor, 22 use of methamphetamine, 23 possession of methamphetamine, 23 failure to report an accident operating without security, 23 possession of methamphetamine, possession of ammunition by a felon, possession of a firearm by a felon, and 24 flee fourth, flee third, 24 another flee fourth, and then 24 flee fourth and flee third. Looks like he is currently on parole.
Can I say something about my fleeing and eluding real quick?
Hold on. Until December of 26. Mr. Stats, what did you want to say about that?
My fleeing and eludings were all the ones from. So I was sent to prison out of Misaki for the fleeing and eluding 3rd degree and 4th degree from there, and then was charged with a fleeing and eluding 4th degree out of Wexford, and they dropped it to the attempted fleeing and eluding because it was the same incident as one of the ones that I was charged with in Misaki. that just went into Wexford, and Wexford joined the pursuit.
Let me take a look because I may have missed the attempt. And you are correct. You are correct. I did miss the attempts. So thank you for that. Okay. Anything else you want me to know about that?
Nope.
All right. Thank you.
That was it.
Mr. Shantz, you know, does he have a parole hold on him?
He does, Your Honor.
All right. Any comment regarding?
This is an important moment that many viewers might overlook. Notice that the defendant doesn't argue that the fleeing incidents never happened. He's clarifying how they were charged and whether some counts stemmed from the same underlying event. Credit where it's due. The judge immediately reviews the record and acknowledges the correction. That kind of exchange matters because bond decisions often depend on accurate criminal history information. But here's the bigger issue. Even with that correction, the court is still looking at a defendant who remains on parole and has multiple prior encounters involving fleeing from law enforcement. So the question becomes less about a single charge and more about a pattern of behavior. What do you think? Should a judge focus primarily on the current allegations, or should a defendant's history carry significant weight when determining whether they're a flight risk?
Bond?
Yes, Your Honor. Thank you. I had the opportunity to speak with John today at the jail. He lives in Lake City at his parents' address. He's been there 6 months since he was released. But he's grown up there. He attended Lake City High School. He spent basically his entire life in the Missaukee, Wexford community. He's currently working at J&H Scrapyards. That's his father's business. He's been there working there 6 months since he's been released. We understand that the flee and eludes on his record, might give rise to this concern that he is a flight risk. However, I do not believe that to be the case. Based on his extensive ties to the community. However, if it would appease the court's concerns, we would be open to a GPS tether, and that would allow him both to remain at his parents' home and also to continue to work because the property that he works on is attached to it's part of the property where the home is. So that would allow him to remain employed. So we would just respectfully request a PR bond. And if the court deems necessary, we would be open and willing to submit to a GPS tether as well. He can abide by a no contact order, and I do not believe that address will impact his housing situation. Thank you.
Mr. Shantz, just a question I have.
Yes.
You had indicated that he works for his father the last 6 months, but the praxis says he works for dad sometimes. Do you know, is that steady employment, or is that as needed, or when it's convenient? Do you know?
It was my understanding that he works pretty regularly with his father.
Okay, thank you. Ms. Dull.
The people have serious concerns, although these two are misdemeanors. It was such a bizarre situation when I read the affidavit of probable cause. It's alleged that he followed the victim and her 2 young children to a vehicle when she tried to get away from him, and then he broke the front windshield when he got on top of the truck, and then broke the back window that threw glass on all 3 of them, and they all sustained injuries from the glass. Additionally, when he fled the scene, he hid some clothing in the woods I'm assuming, to change his outfits to be able to escape detection and arrest in this situation. So I believe he's still a flight risk. As his past criminal history shows, he is a flight risk. And additionally, I believe he is a danger to the community. So I would ask for a monetary bond in this case of at least $5,000 cash surety, no contact with the victim, no weapons or firearms, GPS tether, random alcohol and drug testing, and no contact with the minors as well.
So you say he hid clothes in the woods. How far away from where the event happened, roughly?
So the victim stated that he hides clothes in the woods and at his sister's house to change clothes when he's in trouble. And when they searched the property, there was a sweatshirt found by the residents
the property where it happened, or?
Your Honor, if I may have a moment.
Sure.
Your Honor, it's not clear from the report whether the sweatshirt he was wearing was found behind the house where originally they were before she moved the vehicle about half hour away, or if the sweatshirt was found at the family property. I will try to get clarification from the officers.
Was he apprehended at the scrapyard or somewhere else?
Yes, I was.
He was at the J&H
All right.
salvage.
All right. Thank you, Mr. Stats. Do you know roughly how much time passed between the event and him being apprehended?
Your Honor, the police report does not clarify the timing. I'm sorry, the probable cause affidavit does not describe it.
Allegedly broke out the windshield and the back window?
So he hit the windshield, but broke the back window where it's shattered. The back window shattered and hit everybody in the vehicle.
Okay. Count one is just referencing a windshield. So is that, I assume that'd be the front. Oh, and window. I'm sorry. Windshield and window. Yeah, I missed that. Okay. All right. I do find that the defendant poses as both a threat and a flight risk. I find that he's a flight risk given the fleas that are in his past. I also find that he is a flight risk given the, well, I don't know the exact amount of distance between where this is alleged to have happened versus where he was picked up at. I do note that it was Liberty Township, and then that would have gone into Lake Township of Missaukee County as to where he would be apprehended at. And then in regards to the allegations that he hides clothes in the woods, the court does consider that as well. The court also considers the fact that he is on parole. So I do believe a monetary bond is appropriate. Bond will be set at $50,000 cash surety with the conditions that Mr. Stadd appear as ordered, keeps contact information current, not leave the state without permission to commit no new crimes. Given the comment on the praxis regarding controlled substance use, I am ordering no illegal drugs, no recreational marijuana, and be subject to random testing. I'm also ordering that there be a no contact with Crystal Parcell. Ms. Dull requested no contact with the minor victims. I don't have those names, but I am going to, I shouldn't say minor victims, the minor children. I don't have those names, but I will order that. Ms. Dull, if you can get with court staff afterwards and give them the names. I'm also ordering no purchase or possession of firearms or weapons, not to act any threatening, intimidating, or harassing behavior. Defendants shall be on a GPS tether under house arrest with conditions set by community correction. Thank you, jail.
What started as misdemeanor charges ultimately resulted in a very strict bond ruling. The judge weighed several factors: the current allegations, the defendant's parole status, prior fleeing and eluding convictions, and the prosecution's claims that he attempted to avoid detection after the incident. While the defense emphasized family ties, employment, and community roots, the court concluded those factors were outweighed by concerns about public safety and the risk of non-appearance. The result is a $50,000 cash surety bond, GPS tether monitoring, house arrest conditions, drug testing requirements, no contact orders, and restrictions on weapons possession. Importantly, today's hearing was not a determination of guilt or innocence. It was solely about release conditions while the case proceeds through the court system. Now, we want to hear from you. Did the judge strike the right balance between protecting the community and preserving the defendant's rights? Or was this bond too severe for misdemeanor allegations? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.